everybody, and welcome back. Today is May 19th, 2022. I'm Jordan Redavid from the John and Jordan on Justice podcast, here with a little bit of a brief case law update if you practice in the state of Florida. Yesterday, May 18th, the Florida's Third District Court of Appeal issued its opinion in Jones versus Ervolino. Now, look, this is not a personal injury or wrongful death case, but it does touch on a recent amendment to Rule Procedure 1.510A, which in Florida is the equivalent of Federal Rule 56, governing summary judgment. As many of you know, last year in 2021, the Florida Supreme Court made substantial amendments to the rule. And I think in spirit, it was to bring it closer together to its federal counterpart, but it actually went a step further. Whereas Federal Rule of Civil Procedure 56 says that courts granting or denying motions for summary judgment should explain their rulings, the Florida rule now says they shall. It's a must. Mandatory. And what we see here in the Jones case that just came out is an example of what could happen if a trial court does not sufficiently explain its ruling. And really what we see happening is, unfortunately for the courts and the parties involved, a pretty substantial waste of time to go through an entire plenary appellate process, win, but the remedy, the win, is go back to the trial court and now have the trial court actually explain the ruling. So this is the case involving probate. Somebody passed away. There was an issue over wills and who's the beneficiary. That doesn't matter so much for our discussion today. What matters is there was a motion for summary judgment filed. It was granted, but in the oral pronouncement and the subsequent written order explaining it, it really just had a sentence which said it's denied, this kind of conclusory statement. It went up on appeal, and the third district, all three judges who heard it, decided to reverse and remand. And basically they went through and they explained that while they are very sympathetic to the busy trial dockets of trial courts and the lack of resources, nevertheless, the recent amendments to the rule are pretty plain in terms of their language. And courts must explain their rulings with enough specificity to provide guidance. And I think that's the critical term that I take away from the holding, which is they're not telling courts what to say or how to say it. Just give the parties, and more importantly, the appellate court who might have to review that ruling, enough guidance as to what arguments you found persuasive, what facts you relied on or didn't rely on, so that the record is sufficiently crystallized. Now, for those of you that either practice exclusively or routinely in federal court, this may kind of be a head scratcher to you because you're probably accustomed to federal district courts or federal magistrates issuing very thorough orders ruling on summary judgment. But for those in state courts in Florida, for years, this was just not a thing. Summary orders were kind of permissible, and that was the standard. But with the rules changing, we need to change our pattern of practice. Now, what does this mean for the lawyers out there? Whether you represent plaintiff or defendants, it doesn't matter. It means the same thing, which is you may disagree with the substantive outcome of a trial court summary judgment ruling. Let's say you move for a summary judgment, but the trial court denied it, or vice versa. Nevertheless, take great care if the court asks you to propose the order. And conversely, if the court asks the other side to propose the order, you might want to carefully review it with a discerning eye, not to nitpick the language in as much as to make sure that the language provides enough specificity so that an appellate court can adequately rule on the merits later. Now, that's one way of trying to avoid this. I think another one is, in the off chance that a trial court doesn't give the parties the opportunity to provide the proposed order it's going to enter. There are many trial judges out there who write their own orders, and that's great. But if an order comes out that you feel doesn't meet muster, then I think it's incumbent upon you to maybe file a motion, not necessarily for reconsideration, right? If there's not a good faith basis to say you overlooked a fact or a law, then don't ask for reconsideration, but ask for clarification. Trial courts can revisit their non-final orders at any time. They could revisit any order at any time, unless it's been jurisdiction's been taken away because an appeal has been initiated. So maybe take it upon yourself to just kindly remind the judge, hey, look, take a look at this case, the new rule. It's a lot of work, I know, but we need a better explanation because the appellate court's going to send it back, and we don't want to waste 18 months or longer waiting for that just to come right back here for a mandate to say, hey, can you please write the order? I think a more extreme remedy that could be available in the right case. So let's say a judge doesn't give the parties an opportunity to write the order. It issues its own order. You feel that order is too conclusory and insufficient. You move for clarification and the court, denies it or doesn't sufficiently clarify it. I think potentially an extreme form of remedy, or an extraordinary one, would be to seek a petition for writ of mandamus. It's an extraordinary writ, which at bottom is designed to have an appellate court require the trial court to follow the law. And in this example, now that the rule has been amended with the plain language, and now that we have a panel decision out of the third, which is not yet final, I'll confess, but I don't see any reason for it to change. Now you've got a good faith basis to say, Judge, it's not me, it's the rule of procedure, it's the case out of the third, and let's all save the time here. So hopefully it doesn't have to get to mandamus, but nevertheless, this is going to come up in all different types of civil cases all across the state, probably for a couple of years until people who are predominantly state practitioners or have long been state judges and haven't been in federal court in a while until we all get used to it. So there's a learning curve. As with change comes an opportunity. So I think this is a good opportunity for everyone to remind themselves, beef up your motions, make sure the facts are nice and clean, the law well set out and explained, and give the judge maybe a really good roadmap. That way, when he or she goes to write their order, if they don't ask you to do it, they can almost use your motion or the response to a motion as the model and avoid this altogether. So that being said, I hope everyone has a great rest of the week and a better weekend. Till next time, over and out.